I hit it on my side. Is that good?
Okay, I see it. Okay, we'll go ahead and get started. For those of you that don't know me, my name is Heather Schultz. I am the outreach coordinator for the Down Syndrome Partnership of North Texas. Wanted to thank you for logging on for Speak tonight. Tonight we have Mark Stratton with us from TSG Financial Strategies. He's going to speak to us about planning options for our kiddos with special needs and what resources are available. So I have turned over hosting capabilities to him. So I'm gonna let him have the floor, and so he'll present. And then if you've got any questions at the end, he'll open that up for you. So you can go ahead now.
Awesome. Well, thanks so much, Heather. We're super happy to be here. It's a privilege to be able to be a part. When I found out about the Down Syndrome Partnership in North Texas, I was really excited. I've got a family of 6, born and raised in Dallas, and my youngest 2 kiddos both have special needs, and so this is something that's very near and dear to my family and my firm, and it gives us a chance to help other people in a way that others maybe not be able to, because we've got the insider information as to how life really looks when you're raising a loved one with special needs. And, at the end of the day, the rubber meets the road when you know how things work together. And I'm going to change the formatting on this. It doesn't look like it's formatted correct. So let me come back in here real quick, and this should take care of it. There we go. Much better. So today we want to help educate everybody about some of the relevant topics that we need to have front of mind. We're going to try to illustrate those as best we can, and then educate everybody about kind of the impact that certain planning strategies can have in leveraging the resources that are available. And I'll just tell Heather, today is part 1 of the education. And we know that you probably have personal questions about your specific situation that you may not be comfortable asking in a group setting. And so after today, we're going to carve out up to an hour of our time to engage with you on a one-on-one Zoom video conference just like this, and answer your questions about your personal situation. At the end of the day, Brett Thornock, who's with us, and David Toops, both from the Nautilus Group. The Nautilus Group is an entity owned by New York Life, who we affiliate with. And because of that affiliation, we gain access to their wealth of resources. And David and Brett are both attorneys that are a part of the Nautilus Group. Brett has a kiddo that has special needs as well. You may see her running around in the background or in his lap. So, Brett, you want to give a little bit of background on you, and David, you want to give a little background on yourself as well?
Sure, I can give a little bit. So I'm like Mark said, I am a Texas attorney here with the Nautilus Group, and what we are is just a resource available to member agents to provide them with, our expertise in legal, tax, charitable planning sorts of matters. And this is, I've kind of carved out a niche myself in this area. Because I have a daughter who some of you might have seen was here earlier. My daughter Izzy is 6, and she has Down syndrome. So she was really excited when I told her I got to participate and share with some parents of kids with Down syndrome. So she thought she'd come say hi. And it is her bedroom I'm in right now too. So, she has every right. So, but yeah, so this has been something that's also, near and dear to my heart, making sure that families such as mine, and sharing some of my experiences as I've gone through the planning process and some of the things I've put in place to provide for her future, or to prepare for contingencies that may happen, and just to make sure that we have everything available for her as she grows up and gets older and does the various things that she's going to do throughout her life. So I'm happy to be here partnering with Mark and sharing whatever I can with you guys.
David, did you want to give just a brief overview of you and kind of your role at the Nautilus Group?
Sure. I work with Brett. Brett and I together put together quite a bit of the special needs planning, Lifetime of Hope. And my background, prior to me coming on board with Nautilus, I've been with Nautilus for a little over 4 years, but prior to me coming on board with Nautilus, I did a lot of estate trust and pension litigation and quite a bit of guardianships and guardianship litigation. So I kind of hit it from a little bit different angle, just because I'm familiar with how the courts work with guardianships, where you actually have to go in and do those types of things. And Brett and I work together quite closely on the planning aspects of for the Lifetime of Hope presentation materials that we have for special needs.
Awesome. So hopefully between the three of us and our collective experience, we can provide some meaningful information to you guys. So while they were talking, I skipped over a slide real quick I'll go back to, but again, this slide says we have attorneys to get a hold of our presentations as well. And none of this is intended to be specific tax advice or specific legal advice. You should always consult the your CPA or attorney with regard to your personal situation. So that being said, we'll go ahead and jump in, and there's kind of 4 key areas that we want to cover today. One area is the lifetime planning, second, needs and resources, third, estate planning, and then lastly, financial planning. But these 4 areas kind of are the components of planning when you have a loved one with special needs. So, our hypothetical family today is going to be the Smith family. So the Smiths have 2 kiddos, Jack and Jill. Jill was diagnosed with autism. In this particular example, it could be Down syndrome, cerebral palsy. The material applies across a wide spectrum of medical diagnoses. But she was diagnosed at 24 months. So Jill is currently receiving speech therapy, occupational therapy, applied behavioral analysis, takes medication. Jack is a typically developing boy. He's all boy, stubborn as can be. My son's pretty stubborn. So, boys can also be fairly rambunctious and wild too. But, the Smiths hope that Jill can go on and have post-secondary education, live independently, work, and then enjoy, all of her interests and passions over the course of her lifetime. And so in order to be able to do that, we've got to ensure, the Smiths have to ensure that there's a plan in place. And so they want to be able to, they want peace of mind that, when they're no longer able to care for Jill, that she's going to be provided for. And I'm going to borrow a very bad joke that I heard from an estate planning attorney. So Brett and David, y'all might laugh at this one, but I was sitting in a client meeting with an attorney, talking about his estate plan, and the attorney said, last I checked, the mortality rate is still 100%. So, going off of his expertise, right? At some point, we either can't, provide the care, or maybe we're no longer here since the mortality rate is still 100%. But, if once that day comes for the Smiths, they want Jill to be provided for. They also want Jill's quality of life to be preserved, and also maximize the government benefits that are available, for her, and protect those. So those are kind of the goals that the Smiths have for Jill. And so where do we start in this lifetime of planning? Well, we've got to know what we've done so far. And in some cases that may be nothing. If that's the case, a great starting point. It means there are no mistakes to undo. In other cases, it's really reviewing what you have done, right? Because from time to time, there may be changes in legislation that cause your documents to be outdated, and they need to be updated. So, starting by assessing what we've done, and then another important thing is really crystallizing that vision for the future. What does the future look like for your specific situation? Is there specific medical care that's needed? Is there specific equipment that's needed? Some of the other issues, not dealing with special needs planning, but your retirement's out there at some point. How are we going to do that and still provide for your loved ones that have special needs? So, Having that vision of the future, being as specific as we can, getting as crystal of an image as possible is always best. So the other things to consider is that traditional planning around retirement, investments, etc., are not necessarily the sole thing to focus on. We also need to be focusing on, when we have someone that has special needs, the public benefits that we need to be protecting or tapping into in some cases. Like David mentioned, guardianship provisions. What trusts do we need to be a part of our estate plan? Supplemental needs, ABLE accounts. So these are the other areas that we have to be thinking about. And so when you combine traditional planning and the special needs planning, that's when you really get that comprehensive plan, when you have a loved one that has special needs. And so some of the pitfalls, procrastination, the wrong distribution scheme, lack of poorly drafted or executed trusts, failing to fund the trusts, no letter of intent, not coordinating beneficiaries, lack of guardianship, no plan. And again, the age-old saying is people don't plan to fail, they just fail to plan. But failing to coordinate with other family members in their planning, right? All these things can lead to a scenario where Jill loses access to the needed therapy and medicine that she needs. She loses access to money and resources to help pay for food and shelter. And then any inheritance that was intended to supplement, right, Jill's lifestyle could be spent on medical bills or housing and just the basic stuff, and not allow her to enjoy those hobbies or support her education or recreational activities. So as far as the needs and resources, we have to know what assets are currently available or what may be available in the future. What public benefits, SSI, SSDI, which we'll talk about. Is there any family inheritance that may be coming? Have family members carved out portions of their estate to leave for the loved one that has special needs? And then is there a potential to earn income in the future? So what are the future expenses? Well, medical, right? Housing, educational, hobbies, interests, enabling our family members to live life and have a well-balanced life, not just the bare essentials. So as far as the public benefits go, we'll hit on Social Security, Medicaid waiver programs, housing programs, and then SNAP or food stamps. So the first thing to talk about is Social Security, and there's two benefit programs available for persons with disability. We have SSI, and then we have SSDI, so Supplemental Security Income and Social Security Disability Insurance. So SSI provides money for food and shelter. And so currently 2020, that's $783 a month. Requirements are that you have to be blind, disabled, or 65 and over. There's also an income and resource test. So you have to have low income and limited resources. And normally if you qualify for SSI, then that's an automatic qualification for Medicaid in most states. As far as the resource test, income is deemed by the Social Security Administration is food and shelter, cash, or assets that could be converted to food and shelter. So basically, it's anything that you've got that can pay for your food and shelter, right? And if somebody else is providing for the food and shelter on your behalf, then that can reduce your SSI check by 1/3 or 33%. So to avoid that reduction, you may want to consider having that individual pay rent or the pro rata portion of rent, or you may be able to run those through an ABLE account, which we'll talk about here in a little while. So anybody that's under the age of 18, the parent's income is going to be deemed or considered as income for that minor child. So if there's unearned income, maybe it's investment income, maybe that's a rental property that they inherit, something along those lines, then that's going to reduce the SSI benefits dollar for dollar. And then if there are any earned dollars, earned income, then that's going to offset SSI by 50 cents on the dollar. And then if that SSI benefit gets reduced to zero, then generally there's no eligibility for Medicaid at that point. So this is a big area, right? So making sure that we've done the right things to preserve the SSI benefits. Now the amount of money that an individual can have and so qualify for SSI is $2,000. $3,000 if it's a couple. So you can't gift or sell resources just to qualify for SSI. What that can do is actually cause you to be ineligible and have to satisfy a 3-year waiting period. So if you have any Uniform Transfer to Minor Acts or UTMA accounts, then that is deemed to be a resource once that individual turns age 21. So 529 counts are not considered a resource. And so again, it's really, really important to make sure that if we do have beneficiary designations, if in our estate plan, we're not leaving dollars and resources directly to someone that is depending on SSI income. We need to have the right strategies in place so that these resources can be preserved. Now, certain items are excluded: a car, a residence up to a certain values, personal items, and then limited balances inside of ABLE accounts. So those are the things that the Social Security Administration will not look at for qualification. Brett, was there anything on the SSI programs that I've missed that you wanted to hit on before I go on to SSDI?
No, I think you did a good. I mean, obviously there's tons of nuances into, Mark mentioned a few of the things that are exempt assets, but there's, a bigger list than that, but they get kind of detailed. Like you can have a prepaid burial plan. You can have, a life insurance policy that has a value up to $1,500. So, when Mark was talking about how we could take the opportunity to go over your personal situation, I think, bringing up those types of assets might be something that would be beneficial to anybody who wants to take the chance to meet with him and just go over specific assets and specific situations, because, it's the list would be too big and too nuanced to talk about here in, this hour and a half meeting. So, but yeah, I think overall we covered it pretty well.
Good deal. Yeah, we might bore people to death too. So, well, then let's go on to SSDI then. And SSDI, so this is generally for somebody who's disabled and has built up enough work credits, or you could be an adult disabled child. And so what's the definition of that? Well, the Social Security Administration says that that's anyone over the age of 18 and unmarried that became disabled before they were 22, and then their parents must have earned enough credits in order to qualify with the Social Security Administration. And then, the individual's parents must either be dead, permanently disabled, or currently receiving Social Security retirement benefits in order for the SSDI benefits to be paid to that individual, to the adult disabled child. So I know I went through that pretty quickly, but let's talk again about some of the benefits here and explore this further. So the benefit that is received is going to be equal to 50% of the parent's benefit if that parent is still living and receiving Social Security benefits. If the parent has passed away, then the SSDI benefit is 75% of the parent's benefit. So we'll look at this in a little bit greater detail later in the potential resources this provides, but it's key to know that the benefit that your loved one is eligible to receive is equal to 50% of your retirement benefit if you're living, or 75% of the parent's deceased. So after receiving 2 years of benefits, generally that individual is going to be eligible for Medicare. And with Medicare, you can be duly eligible for Medicare and Medicaid both. And so it's not one or the other. You can be duly eligible. So as far as Medicaid goes, I'm going to pause real quick before we hit this. And Brett, anything on SSDI?
No, just again, talking about the coordination of benefits. When a person starts receiving an SSDI, they're going to make too much money to now qualify for SSI. So the conversation there needs to be, well, how do we ensure we get the proper medical benefits that we need, and now that we're getting this increased financial payment. So again, making sure that there's other ways to qualify for Medicaid, not just being on SSI. So then you have to kind of do the extra legwork of saying, okay, well, we're going to make the individual's going to make too much money now because of the SSDI benefit, but can they also still find ways to get the healthcare benefits that they need?
Good point. Thanks for pointing that out. So let's move on to Medicaid. And so with Medicaid, well, that's a joint and federal, that's a joint program between federal and state that provides healthcare coverage to millions. And so to participate, again, you've got to qualify based off of your income and resources. Certain assets are going to be exempt. And it's generally kind of the same list we just talked about, right? Home, primary residence, not a second home, up to certain limits, one car, personal belongings and effects up to certain limits, cash and other, assets up to a minimal amount of, $2,000, $3,000. So again, Medicaid is intended for those that really need it, right? And don't have any other resources to provide for the basic healthcare needs that they have. So also, qualified pregnant women and children may be eligible, and also individuals receiving, again, SSI would be eligible for Medicaid as well. And so since this is a state-based program, it's going to, if you move outside of Texas, it's going to change, right? Different states have different programs. So Brett, I'll come to you again. Anything on the Medicaid front before we move on?
No, I mean, it will be important to note that, Medicaid will look personally at your stuff. They require audits of people's personal assets and resources and trusts that you have. So, we'll talk about special needs trusts later on, but, they are actively engaged in making sure that the qualification stays current.
Absolutely. I've never seen the government pay benefits out without making sure someone was absolutely deserving of it. So, and sometimes that can be a very, very arduous process to go through. So, some of the other programs, we've got Medicaid waiver programs. Probably some of the more prominent ones would be the CLASS program or the MDCP program in Texas. In preparing for this, I was pulling up a list of these, and it looks like it's the HCS, Home and Community-Based Care CLASS, which I just mentioned, which is Community Living Assistance and Support Services. MDCP is Medically Dependent Children Program. STAR Plus, Home and Community-Based Services. Texas Home Living, Youth Empowerment Services, and then Deaf Blind with Multiple Disabilities. We're all listed in Texas under that Medicaid waiver program. So the SNAP and food assistance, again, helps provide for assistance for food. And then Section 8 housing vouchers help lower the cost of housing at the end of the day. Most of the time with the Medicaid waiver programs, I'll go back to those real quick, there's going to be a waiting list. There may be ways to try to cut the waiting list down at the end of the day. Y'all may be familiar with the money follows the child provisions in the state of Texas. If not, but that is a way where for the MDCP waiting list, you can try to jump ahead, if you will, if you follow certain provisions. So just something to be cognizant of. With my 4-year-old, we're in the process of going through that right now. She has cerebral palsy, was born 31 weeks, had a severe stroke. And the NICU doctor told us that he had never seen a baby that sick leave the hospital in his 30 years of practicing medicine. So, we're in the middle of that process right now. She's been on the waiting list. We're trying to not circumvent the waiting list, but just speed that process up through the Money Follows the Child programs. So, Brett, anything on these 3 areas before we move on?
No, yeah, you hit that pretty well. I mean, my personal experience, we got on all these waiting lists when Izzy was born, and I think 6 months ago we finally got contacted by MDCP to see if we were, and she's almost 7 years old now. So if you're not on these, it's definitely vital to get on them as soon as possible, because the waiting list can be decades, years, if not decades.
Yeah, absolutely. The HHS was telling me that the waiting list was, something like, did they say it was like 10? I don't know. I'm going to get this totally wrong, but it was some astronomical number. I was like, oh my gosh, that's insane. And at one point I saw that, I think on the Medicaid website for Texas, the waiting list had somewhere around like 100,000 people on the waiting list. I was just going, wow, that's mind boggling. But anyways, we'll keep going. So as far as the resources and needs for the Smith family, so Jill can receive government assistance for just the basics, right? Food, clothing, and shelter. So those benefits would be provided to her if she's at or below the poverty line. But that doesn't include the other goals that the Smiths have for Jill, which is her education, being able to live independently, being able to travel and just enjoy life, her hobbies and interests. So how do those things get funded? Because we know it's not through we know it's not because of the government. At the end of the day, the government barely provides enough assistance just to meet the bare essentials. So the real question comes in as far as how the Smiths can bridge the gap between Jill's available resources and what they want her to have without jeopardizing those benefits. So at the end of the day, the Smiths can disinherit Jill and leave everything to Jack. We better hope Jack knows what he's doing and doesn't decide to take the money and go spend it on something else. Or, another common scenario when that happens is that Jack may be very financially responsible, accidentally clips some car while he's driving, and that ends up in a civil liability. And if, again, depending on the situation, that could rob Jack of all those resources that were intended to go for Jill. So there's got to be better options, though, and we'll cover those as we go through and unfold what the Smiths should be considering as a part of their plan. And so we're going to start with the estate planning side first. And so historically, I've always found people think, oh, estate planning, that's for people that have millions and millions and millions and millions of dollars. They're trying to avoid estate taxes. Well, it's partially true, but in this case, not entirely, right? So with proper planning, the Smiths can use strategies to leverage the public resources available and still provide for Jill and supplement what the government is not going to take care of. So as we go through here, we're going to talk about several things. We're going to talk about special needs trusts. We're going to talk about ABLE accounts, which I know is a very hot topic right now. We're going to talk about guardianship. And David, I'm going to come to you here in a few minutes on the guardianship issues. And we're also going to cover letters of intent and what those are. So first things first, special needs trusts. There's several types. The first type we're going to hit on is called a first party or self-settled special needs trust, also sometimes known as a D4A trust. So if you hear any of those terms, first party special needs trust, a self-settled special needs trust, or D4A trust, this is what they're talking about. But with these types of trusts, this is money that in the Smiths case, it would be Jill's money. And she can contribute those funds into the special needs trust, whether it's money in a bank account, child support, inheritance, a gift, personal injury settlement. These trusts are designed to be irrevocable, meaning once you set them up, we really can't make any changes to them. They can only benefit, and again, the Smiths case, Jill, or they can only benefit, our loved one that has special needs. And it's for individuals who are under the age of 65. So if it's a brother or sister who's over 65 that we're providing care for, or a parent in some cases, then this probably doesn't apply. The one thing to be aware of and cognizant of is that in a first party special need trust, Medicaid gets paid back if there's anything left in that trust. Now, you might ask yourself, well, why in the world would I do that if Medicaid can still get to the dollars? Well, one thing that we may want to do is take advantage of it simply because Medicaid can provide more cost-effective care, right? So if we can tap into the Medicaid benefits and let Medicaid pay for things at a much lower rate, we may be able to cut the cost in half to more in some cases. And so if we look at a payback situation, it may be that we're paying back less to Medicaid than if we tried to self-pay. But the advantage of this first party special needs trust is that you would be, again, if you're getting resources out of your name into this first party special needs trust, then that individual that has a medical condition would be able to qualify for Medicaid because of this payback provision. And again, that payback provision is going to be state dependent. So I was looking at Texas as an example, and I pulled up the website under the FAQs. And so in Texas, here's what they say. says, first, all outstanding requests for withdrawals for qualified disability expenses, including funeral and burial expenses, will be paid from the account. Next, any state that has provided Medicaid assistance to the designated beneficiary may be required to file a claim against the designated beneficiary's estate or the account for the amount of the total medical assistance paid for by the designated beneficiary under the state's Medicaid plan after the account or any able account from which the amounts were rolled over or transferred to the account was established. So essentially, Texas is saying, yep, we're going to allow others to petition to claw back money paid out. So that's the caveat of the first party special needs trust. So, Brett, anything else on these before I move on to third party trusts? So
in many situations, the first party trust only comes into play if we haven't planned properly. Meaning, grandparents leave a sizable gift to the individual with special needs, and there's now nothing they can do to keep that from disqualifying them other than putting it in this type of trust. So these are kind of the ability to correct if things weren't done properly on the front end. They can still get their benefits and all that money, during their lifetime, they can use it to spend it on their supplemental needs. But at the end of the day, there is that chance that some of it could be used to pay back. So that's why, that we'll emphasize the next types of trust, but just to realize that, these are mostly put into place other than, primarily for personal injury settlements when there's been a mistake or when things haven't been done properly from the get-go. That's why it's so important to kind of prevent that by, being proactive.
Yeah, I think, another attorney that I attended the conference was talking about how pre-planning doesn't always go the way that you want it to, but generally more times than not will. Crisis planning generally doesn't. So, pre-planning and forethought probably always trumps. So thanks, Brett, for the additional comments on that. So the next type of special needs trust is going to be called a third party special needs trust. And so this is a trust funded with somebody else's money. So it could be grandparents, parents, siblings, really, anybody that wants to allocate dollars into a trust that is designed to supplement what the government benefits are going to pay for. And so this third party, it can be, a gift during lifetime. It can be from a what's called a bequest, which is a specific request made out of someone's will. It can be funded with life insurance, retirement benefits. And the advantage to these is that Medicaid doesn't look at it as an available resource to claw back from. So it avoids that Medicaid payback provision that the self-settled special needs trust have. So any remaining dollars in these trusts can go on to other family members. In the case of, the Smiths, they could, leave the money to Jack, assuming Jack hadn't made his mom and dad mad, and they still like him. Otherwise, the Smiths may decide to disinherit Jack altogether and leave the funds to a charitable organization. But with a third-party special needs trust, those dollars are designed to go into the trust, be overseen by a third party for the benefit of our loved one that has special needs. And so that can be the trustee, the person overseeing the money, can be a corporate trustee, it can be a family member, a friend. There's really not there's not a restriction other than the disabled individual, right? That the individual has special needs cannot serve as the trustee. But outside of that, I'm not aware of any restriction that would say someone cannot. Now, there are better people than others to serve as a trustee, of course. So that's something that you want to give specific thought to, is who would be an appropriate trustee to serve in that capacity. So, Brett, on the third-party special needs trusts, anything that I've misspoke on, or need to add?
No, I will just emphasize, from the attorney perspective, is just ensuring that you find somebody who's qualified to do these, because like I was saying before when discussing Medicaid, is Medicaid many times will ask to see the copy of the third-party special needs trust to make sure that certain language isn't included in there, which they would then come back and say, hey, this language says that these types of assets are available to them, so we're going to count them against them as far as qualifying for Medicaid or SSI. So, the very tiny details in there can make or break the efficacy of a special needs trust.
Yeah, absolutely. You absolutely have to go to somebody who's qualified, competent, et cetera. And fortunately, thanks to Brett and David, we've got the ability to review these documents to make sure they're done the right way, and kind of bring back some commentaries around, hey, these are the things you may want to consider or look at or revisit, et cetera. And then go back to the person that drafted it in the first place and work with them to get those issues resolved if any exist. So as far as special needs trusts go, generally they're most commonly created either by parents or grandparents, while the parents or grandparents are still alive, or it can be created at their death out of a trust formed from their will. Again, I mentioned earlier, our family member that has special needs cannot have any control or discretion over the dollars. Otherwise, it completely defeats the purpose of having this special needs trust in place in the first place. So the distributions from the trust are made at the discretion of the trustee. So again, that can be a third party, it can be a corporate trustee, it can be a professional trustee, if you will, or family, friends, etc. But again, I'll reiterate, you need to give careful thought to who serves in that role. So as far as the remainder beneficiary, so who gets the money after our loved one passes away, well, you don't want to name the estate of our loved one that has special needs as the beneficiary. That, again, completely defeats the purpose. We would want to name other family members or charities, et cetera, as the remainder beneficiary. So additional key things, again, the benefits are not designed to replace or supplant government benefits. The benefits and the language of the trust is drafted so that it supplements the government benefits. And thereby, that's why it doesn't disqualify someone from receiving those benefits. One, because our family member doesn't have control. Two, they're not replacing the government benefits, and they're there simply to support what the government does do to give our family member a better quality of life. And like Brett mentioned a minute ago, it is paramount to seek an experienced, competent attorney to draft these documents, because one minor thing that gets left out can completely derail this whole thing. So if we look at how the special needs trust ties in with everything else, we have the government benefits, right? Social Security and Medicaid. Those benefits get paid to our family member. Then we have the special needs trust over here on the right side. And so that can be funded either from assets, investments, retirement accounts, life insurance, et cetera. Life insurance can be a good tool to use at the end of the day, because it may cost us less to leverage a life insurance contract versus self-funding. But the money goes into the special needs trust, whether that's gifts, inheritances left to the trust, et cetera. And then that gets overseen by our trustee, and then money gets dispersed out for our loved one to supplement the government benefits and bring up that standard of living. And again, if Jack in the case of the Smiths doesn't make mom and dad mad, he gets to inherit the rest. If he does, then some charity is going to be the benefactor of those dollars. So as far as the Smiths go, with their special needs trust, they used it to supplement Jill's needs. So school, transportation, vacations, hobbies, the electronics she needs. The grandparents left their dollars that they were going to leave for Jill to her special needs trust. And then the special needs trust appointed a professional trustee so that Jack didn't have to worry about anything other than just being a big brother to Jill. And that's a big deal. Oftentimes you can see a real strain on family relationships if siblings have to take on a predominant role in caring for their siblings. Not that they don't want to do it, not that they don't love doing it. It places a little bit different relationship and emphasis there. So sometimes that professional trustee frees family up to just be family. And so the bottom line, though, is that Jill gets to keep her SSI Medicaid benefits. And so it's maximizing the government benefits she has and then supplementing those so that, again, it enhances the overall resources that the Smiths have available for Jill. So before we go on to ABLE accounts, Brett, anything that I've missed or we need to go back and hit on?
No, I think we covered it pretty well.
Good deal. So then I know we'll move on to the hot topic, which is ABLE accounts. And when we were preparing for this, Heather and the Down Syndrome Partnership in North Texas really emphasized, hey, do you cover ABLE accounts? So we're going to spend a little bit of time here as we go through. One of the things I was remiss in mentioning is that if y'all have questions, we're going to stop at the end, but you feel free to use the text chat feature to enter those in as we go so that you're not trying to remember those questions. If you enter those questions in as we go, we'll come back and hit on those at the end. So feel free to type those in to the chat field as we go, and we'll come back at the end and deal with all those questions. And if we need to, we can go back to a slide. So ABLE accounts, relatively newer. And so in order to be eligible for an ABLE account, someone must have been disabled prior to age 26. So the account balance is not deemed as a resource for SSI in the eyes of SSI and Medicaid, so long as we don't have more than $100,000 in our ABLE account. So the first $100,000, not deemed as a resource for SSI and Medicaid. If the distributions are used for qualified disability expenses, which will be abbreviated here in the coming slides as QDE, just FYI, then that's not viewed as a resource for SSI and does not count against the SSI income. The ABLE accounts are eligible to disperse funds for food and shelter, whereas our special needs trust couldn't. The ABLE accounts can. And so a couple other things to be cognizant of: you can only have one account. So you can't have multiple ABLE accounts to, in the aggregate, be more than 100,000. You only have one. And so Medicaid may be paid back by the ABLE account. And again, that's if elected by the states. And so from state to state, that provision is going to be different. The ABLE accounts are also useful for, again, we talked about paying for food and shelter without the reduction of the 1/3 of SSI. It allows a person to save earnings, and then small gifts and inheritances can be contributed into the ABLE account. And one other thing I was remiss in mentioning a minute ago, the small gifts, each year you're going to be limited to $15,000 a year that you can contribute into the ABLE account. So some of the tax benefits of the ABLE accounts are that the investments can accumulate tax deferred. So you can invest money inside of there and stock mutual funds, bond mutual funds, ETFs, et cetera, which is a whole nother discussion. You want to make sure that the dollars that are in there, you're not depending on tomorrow and have 100% of it in stocks. Because when a month like March rolls around, you might see that ABLE account get cut in a third. So you want to make sure the investment mix inside of the ABLE account matches your time horizon, risk, investment objectives, et cetera. But any earnings would accumulate tax deferred. And then we talked about a minute ago, those QDE, qualified disability expenses. So long as they're withdrawn for as long as money's withdrawn for those benefits, then they come out tax exempt from income taxes. And you can roll over a 529 plan into an ABLE account. So I'm going to stop there for just a second. Brett, I know there's probably a couple things you want to hit on in as far as the nuances of the ABLE account, so I'll let you talk for a few minutes on ABLE accounts.
Okay, sure. Mark touched on one about the $15,000 limitation. That's a cumulative limitation, meaning not every parent and grandparent can put $15,000 in, but that means the total amount that can be put in is that $15,000 per year. And that includes contributions from a special needs trust. So this is, it's been kind of a new planning technique of, the special needs trust trustee can deposit money into the ABLE account, then the ABLE account can use that to pay for food or housing, eating out, even stuff like that. But it is still important to be mindful that that $15,000 is a cumulative amount, so you can't go too crazy doing things like that. So I mean, that's kind of the biggest thing. There is legislation currently pending. If anybody follows those kinds of updates we get often from like the Down Syndrome Congress and stuff like that. They're trying to up that age for eligibility to age 45, and they're trying to increase the amounts that can be contributed. So, that's something to look for in the next couple of years, is updates and changes that may happen to these accounts, which may even make them more beneficial.
Brett, I know when you and I have talked previously, and correct me if I'm wrong, one of the things that an ABLE account can have, doesn't always have it, but can have, is a debit card. Is that right?
Yeah, depending on what state, and you can open an ABLE account with any state, and in Texas especially, it doesn't really matter. Some states offer you a state income tax credit if you open an ABLE account with their state's plan, but since we don't have a state income tax here in Texas, it doesn't matter where you open them. And so certain states that are very well established in this, particularly Ohio. Ohio is very well established in this. It's called a stable account there, and they even offer debit cards. And the debit card, depending on the code of what you're buying, is limited in whether or not it can pay for certain things. So it can be also beneficial to give our loved one a little more independence and say, hey, take this card, you can go buy what you want with it. And the code will limit what they can purchase, but it'll also still, as long as it'll keep them qualified for those QDEs, as we talked about.
Good deal. So then, again, if you've got questions, enter those into the text chat area. And again, we'll come back and answer questions at the end that you all ask us. Sometimes I find it beneficial if, as I'm listening to something, I just enter a question into the text chat, let them come back and address it at the end. So feel free to take advantage of that, or we'll circle back at the end with questions. So David, you're going to be in the hot seat here in the coming slides I'm going to turn to. So just FYI, getting you heads up. But now we're going to deal with guardianship. And so guardianship is basically someone that gets appointed to act for another person who's been determined incapable of acting for themselves. Now, if a guardian is appointed, it takes a formal legal proceeding in order to establish this. So you got to go to court. There's court costs, attorney costs in order to establish guardianship. But once that guardian is appointed to act for someone else, the role in which they're acting, that individual is no longer essentially eligible to act on their own behalf in that area. So you can have a guardianship appointed for financial matters, or I say financial matters, but for the person or for the person's property. And again, if that guardian gets appointed, that individual gives up their right, if you will, to make decisions on their own. And so while guardianship has certain ramifications and may be beneficial in some areas, it may not be the end-all be-all that necessarily takes care of everything at the end of the day. And so with guardianship, some things to consider is that you may not have to go through a formal guardianship hearing. You may be able to get the job done through powers of attorney for financial matters, or powers of attorney for medical matters, designated payees, and or advocates, if guardianship is not needed. And bottom line, sometimes these things can be used to give a little bit more independence to our loved ones without essentially taking their ability to make those decisions away from them. So, David, I'm going to again turn to you here real quick. And within the area of guardianship, what have I missed? What do we need to point out? So fill in the gaps that I know I've probably missed.
Well, for guardianship, one of the things that you need to keep in mind, depending on the person, you have to have capacity at some point in order to execute a valid power of attorney. To be able to appoint someone else to act on your behalf, you have to have capacity to do that. So, for example, say you have a child with special needs, and they're getting ready to become the age of majority. In Texas, it's 18. The way our system works is at age 18, you're presumed to have capacity, and and all of your constitutional rights spring into action on your 18th birthday. If someone holds you against your will, you could sue them for false imprisonment. You have a right to choose your doctor and allow the doctor to act on your to basically touch your person and heal you. If you have a child that's that has special needs and they would not be found to have capacity upon their 18th birthday, if you don't have a guardianship up in place, real issues could arise, because technically there would not be somebody there who would be able to give a doctor consent to provide medical care to this person, or take care of any of their financial, their contractual needs. If you could have somebody who could go in and swindle them, and this happens quite a bit in guardianship. And so you can, the guardianships are narrowly tailored, and it could be something that they're very expensive because everything requires court approval, everything. So the most effective means is to plan ahead. If the person has done capacity planning and they do have capacity, they can assign powers of attorney, which are important documents to have. But if you have a child that is not going to have capacity once they reach the age of 18, a guardianship of the person would be a very wise thing to do. Texas allows you to file that 6 months prior to their 18th birthday, so you can have everything ready to go and have that person ready, the guardian ready to go for that for your child, for that child that's about to become of age. And if you have all the assets lined up right, all you would really need would be the guardianship of the person. And it could be very, very narrowly tailored. And that's a nice way to do it. And what you're doing is you're really limiting the expense that you would have in having a guardianship up and running over time. But as far as safety goes, you know, a guardianship of the person is probably one. You can get around guardianship of the estate if you've done planning with trust, able accounts, designated payees. You can cover a lot of things with a guardianship of the estate and avoid that completely. But getting around the guardianship of the person, especially if the person has never had capacity, is tough, and you run the risk of having a doctor or a physician that understands or has been sued, and at that point he's going to refuse service because no one's there that would be able to give consent, informed consent, to allow services to be performed on the person.
Well, sorry. Yep. I have a running joke with this, and I wasn't planning on using this, but I hope everybody has seen the movie Rush Hour with Jackie Chan and doggone it if I just forgot the other guy's name. But Jackie Chan goes, "Do you understand the words that are coming out of my mouth?" And the other gentleman responds with, "Man, there ain't nobody that understands the words that are coming out of your mouth." So that's kind of my running joke when somebody's left on mute, which I did myself just now. That no, nobody understands the words that are coming out of your mouth. But anyways, thanks, David, for the explanation. Again, I told you I was going to leave a lot of stuff out, so thanks for filling in those gaps. So moving on here, we're going to talk about letters of intent. And so these have no legal binding ramifications at all. They're not a true legal document, but this is where you can really communicate your desires and wishes to other family members or to whoever is going to be a caregiver for your loved one that has special needs. So it's informal guidance to the trustee and the guardian. It just expresses your wishes from your personal standpoint, right? And it fills in kind of the context around what you intended to do or what you intended to have happen. And so that letter of intent can be a very, very valuable thing to not just communicate intent, but also think about all the things that we know about our kiddos or our loved one that has special needs. I mean, my 4-year-old, she's nonverbal, but yet she has her own way of communicating with us. She loves to blow kisses. She loves to sing in the car to music. Somebody else is not going to know those intimate details like you do. And so that's your chance to really detail and outline to somebody else, hey, these are the things that, so-and-so likes to do. This is the way they act when this happens, or this is, what they do in these different circumstances. Oh, be aware, don't do this, right? And so that letter of intent, just, again, it's informal guidance to the trustee, the guardian. It expresses your wishes, your desires, and kind of helps fill in the gaps, provide context, et cetera. And so that can be a very, very important piece in helping somebody fill in the gaps and kind of get past that learning curve that you've experienced over a lifetime, quite frankly. So, with that, Brett, anything on the letter of intent that I didn't hit on or that we need to cover?
Another way I always like to look at these or creating these is, as you go through creating a letter of intent, it also kind of helps you to identify what things you want to provide for should something happen to you. If you're going through and you're saying, hey, this is a hobby. They like to, do this activity that's going to cost this type of fee on a monthly or annual basis. That helps you to, in your planning process, to create an adequate, kind of projection of what kinds of funds you need to have available, because you've been able to sit down and identify, these are their likes and dislikes. Hey, they've got a brother or sister that lives out of state and they're going to want to go see them twice a year. So we want to make sure there's enough funds to provide them with those types of opportunities. So, it's kind of a dual-edged sword. It helps to communicate that information, but it also helps you as you create it to identify what are the things that are going to be most important for you to provide in the future.
Good word right there. So I'll leave it at that. And this whole process, it requires a team approach because really you have the chance to create this, person-centered process, right? That keeps the focus on, your family, your loved ones, and your goals and objectives at the end of the day. And so, the team is important. And it's important everybody's on the same page. The financial advisor knows the specific situations, and going back to that letter of intent, right? That they understand the context of the big picture. The trustee knows, the care manager, the rest of the family, the guardian, the attorney. And Brett, one of the people we left off here is the CPA. But it's important the CPA is on the same page at the end of the day. And so over time, you continue to review and modify and collaborate together as things change. And so this team process and collaborative approach centered around your loved one that has special needs helps to make sure that everything stays on track. So, as far as a specific example, we want to help kind of the quote unquote rubber meet the road and illustrate how these public benefits can help offset and defray your costs. And so with Jill, she's currently 10 and she has a life expectancy of approximately 75 years. And so we estimate that the lifetime cost for caring with somebody that has her specific set of medical issues is between $1.4 to $2.4 million. Now, most of us, we see this number, we go, oh my gosh, there is no way in the world I can save that much money over my lifetime and still fund my retirement. And in most cases, I'd say, the clients we work with, that's probably pretty true. And so we need to find the strategies that can help cover these costs, right? That maybe it's not out of our own pocket, but we're leveraging the resources that we have. And so in this $1.4 to $2.4 million, some of these costs are medical equipment and treatment, counseling, therapies, food, clothing, education, housing, social activities, technology, travel, etc. And so, how do we come up with $1.4 to $2.4 million and still make sure that the rest of our plan stays on track? And that seems like a pretty daunting task to me, and for somebody who works with numbers. So, if we look at, again, keeping in mind the benefits and resources available to Jill, if Jill could receive SSI of $783 a month once she turns 18, then if we assume she receives that until her father hits normal retirement age, then that means she'd have SSI income of 783 times 12 months times 27 years. That comes out to $250,000 of resources. Well, that's not a small amount of money. Then when Jill reaches 45, her father decides to retire, and his Social Security benefit is projected to be about $3,000 a month. Well, so long as he's alive, Jill receives 50% of that as an SSDI benefit. So that's $1,500 a month. And then 15 years later, her father passes away, and Jill's already received $270,000 from SSDI. Now, Jill's going to get 75% of her father's Social Security benefit at $2,250 a month, and that's another $400,000 of resources before Jill passes away. And so, if we look at the combination of these benefits, $250,000, $270,000, $405,000, that's a lot of money. $931,000 worth of benefits, not including any cost of living adjustments. Well, that puts a pretty big dent in our $1.4 million to $2.4 million need that we talked about a minute ago. So if Jill, works, then these available resources go up. If Jill's father, if his benefits are higher, let's say he delays Social Security longer, well, it could be that his benefits are higher. And so these decisions over when do we trigger Social Security benefits, how does that impact family, that becomes a big deal, especially in situations like this. So, at the end of the day, if we tap into what the government has, right, through the Medicaid waiver programs, SSI, SSDI, SNAP, Section 8 housing vouchers, that can help defray a lot of the cost. But guess what? Jill's not going to automatically qualify for those benefits. There are going to have to, in most cases, be additional funds added to that. And so whether that's savings from the Smiths, family members leaving dollars for Jill's benefit through gifts and inheritances, whether that's life insurance, there's a lot of ways that gap can get funded. So if we try to tie it all together for the Smiths, then really the key to preserving Jill's benefits and supplementing those benefits, right? So we don't derail this $930,000 asset, because that's the way to look at it. These public benefits represent a $930,000 asset in our example case. So to round that out, then the Smiths can use life insurance. They can use the inheritance that the Smiths' parents would have left them, if any, or their retirement accounts or additional savings. They can leave all those things to Jill's Special Needs Trust. Then the Special Needs Trust can allocate dollars into an ABLE account for Jill's benefit to use for food and shelter, then supplement Jill's other needs for technology, hobbies, interests, travel, and the things that the government benefits are not going to pay for. And then if Jill doesn't need all those resources, then the balance can be passed on to Jack at the end of the day. But Jack better obey and not make mom and dad mad, because if he does, then the charity gets it. So, anyways, I always joke with my clients that, has your son or daughter made you mad yet? No, they're okay. Then they're still in the will. Good. So, the end result in all the planning the Smiths did was that Jill was able to pursue her education, her independent living, her hobbies, while maintaining access to the public benefits. Jill's future needs could be provided for, and her, the money that the Smiths left, that the Smiths' parents left, was not going to get eaten away by paying for the medical, food and shelter that the government would pay for. Because they made a corporate trustee or a professional trustee, the trustee of the Special Needs Trust, Jack can live his life and focus on his relationship with Jill and not having to be a caregiver. And then, the end result is that we've provided a better life for the Smiths, provided a better life for Jill, but also Jack as well. And so through pre-planning, this is the result that it has. But this doesn't just happen on its own. It takes willful actions in advance. And so there's a lot of caveats that have to be thought through. I saw in the text chat feature of the Zoom meeting that we had a comment that there was an individual that had obtained guardianship for their son when he was 18. Now their son is 30 and he wants to go vote. And, the comment was that there's this sense that maybe that right was taken away from their son. And so, again, the guardianship provisions, the special needs trusts, all this stuff, because there's so many variables, you've got to look at it on a personal level. There's no way around that. And so the best thing that anybody can do is take the time to sit down, think, where am I now? What have I done? What do I see the future looking like? How do I preserve benefits and map this thing out? Because it's not just, our loved one's financial future that's at stake here. It's our own as well, because we all only have so many resources to go around. And so at the end of the day, what we want to make sure of is that we have the available resources to provide for our loved ones and ourselves. And through proper planning, we have a better chance at making that happen. And so what I mentioned on the front side is that today's part one of the education. Part two is where we do want to connect with you in a one-on-one setting. And that's not a chance to talk about financial products or anything like that, or services. We're just going to deal with the issues that you want to talk about and the questions that you guys have about your personal situation that maybe you're not comfortable asking in the group setting. So, we want to help you understand where you need to be headed. We want you to be able to understand what steps you need to be taking, what maybe hasn't been addressed. And to do that, we're willing to allocate up to an hour of our time to deal with that. If you've got documents that you'd like for us to review, Brett and David and the Nautilus group, we can arrange for them to review the documents and provide some key point summaries, right, on what's there, what they see that may need to be addressed given your specific situation. And so we'll be thrilled to have the opportunity to do that. In a moment, what my goal is to paste in the text chat field. Mike Stratton, who's my brother, he runs all the operations at our office, is on with us. Mike, could you paste that link into the text chat area for me? Because I don't have that on hand, but if you could text chat that in so that folks can take advantage of that, I would appreciate it. Or you're welcome to call the number on the screen or email me as well, and we'll coordinate a time for that one-on-one session. But this online survey gives you a chance to put name, phone number, email address, and then give us some feedback around your thoughts today with the session. It also helps us kind of pass feedback back to the Down Syndrome Partnership in North Texas so that they know what you thought. And so with that, I'll leave it there, Heather, and just open it up for questions that folks have. And so, Heather, folks may have to unmute themselves. I can probably
I
can mute them as well if they want to just use the raise the hand button.
Hey, Mark, this is Mike. I tried to type the link in. It looks like my privileges are not set to paste anything into the chat. So I just emailed the link to you. So can you just copy and paste that in there real quick?
I'm sure I can. Give me just a sec here. If my screen
Sorry
goes
for the
dark,
technical difficulties, guys.
if my screen goes dark, then bear with me for just a second. Here we go. Hang on just a second, guys. I'm going to copy. Okay. Chat. Paste. Done. So I know if you're using an iPad or iPhone or some smart device that sometimes doesn't act very smart, you can probably click on that link and it'll take you to the survey. If you're using a PC or Mac, you may have to kind of like copy it or highlight it, copy, and then paste it into a web browser to navigate to the survey. But if you guys have any questions, feel free to unmute your mic, and would be more than happy to answer those questions at this time. Or if you know how to use the little raise your hand feature, then I'm happy to try to unmute you that way as well. So any questions for me, Brett, or David?
The shy group tonight.
That's all right. It can't be that we presented so well that there are no questions.
That's what it was.
Okay. Our son's 31. We decided. I mean, we had all the paperwork together and we were ready to go to court, and decided not to do the guardianship because he's very compliant. And but the question is, in our wills, we have just redone our wills to not leave him anything that's going to go to his sister, who's going to be where he's going to go stay whenever we're not here. Does that sound like a reasonable thing to do?
Because it's our understanding that should anything be left to him in a will, that it would disqualify him for his Medicaid benefits.
So,
oh, sorry. Mark, do you want me to answer this?
Let me take a stab at it, Brett, and then I'll see if there's anything I missed. How about that?
Perfect.
So very kind of concisely, one strategy that we looked at earlier was leaving everything, to Jack in the scenario. So if you leave everything to your daughter for her to take care of everything, then that's a strategy. Is it the best strategy? There might be some things to think about, right? So if there's, the example I used was a car wreck, right? If there's some civil liability that arises or a creditor that comes looking for money, then basically those dollars are not protected for your son's benefit. They're available to be cabbaged onto by, even if it's not like a credit card company, but if there's that accident or somebody trips and falls on her property, then those dollars are exposed to that type of what we call predatory creditor. To us, perhaps the better choice to consider is leaving those dollars, instead of directly to your daughter, leave them into a special needs trust. And if that third party special needs trust specifically would be the type of trust. And then if you want your daughter to oversee the trust as a trustee, then you could consider doing that. But rather than just leaving the money outright, probably the better strategy to consider would just be leaving it to that special needs trust for his benefit.
Okay. Thank you.
Brett, anything?
Yeah, just a couple more caveats to that. Like, I don't know everybody's personal situation, but it's also important to note that, in Texas, we have separate property and community property. So if you left all the assets to the sister, that would be her separate property, separate from, if she's married, separate from her husband. However, should they intermingle the money that she receives as an inheritance, and then, they were to get divorced, or he had a creditor, that intermingled money then also becomes subject to his creditors, meaning, they get divorced, he could go after that money as well. So, all that money that you left to her, depending on whether or not she's able to strictly keep it her separate property and completely separate from her spouse or whomever's, you kind of run that risk. And, just to kind of a follow-up, if you're kind of afraid about the cost of a special needs or a third-party special needs trust, there are in every state something called a pooled trust. And a pooled trust is just the same as a third-party special needs trust, but the cost and the administration is a lot lower because they're taking money that's meant for individuals with disabilities from all over the place and pooling it together with one administrator. So it can really help keep the costs down if that's kind of a concern there. But, just as Mark was saying, that protection from creditors, from divorce, from all those things, it's really is a big deal as far as not leaving things to people outright.
Okay, thank you.
You're welcome.
Absolutely. Happy to share our thoughts. Any other questions?
You can unmute yourself too and ask. You don't have to type it.
Mark, I'll just make a follow-up comment. This is something from my own personal situation is, when I started kind of putting the plan together for my daughter is, I made sure I had conversations with my parents because of a few different reasons. First, my parents had already created all their estate planning documents, so they had their trusts and their wills. So I had to go back through and tell them, hey, you need to update yours, because in the off chance that something is left to Izzy, I don't want it to go to her outright. So I need you guys, and I even gave them a little blurb of language. I said, hey, put this in your trust that says, instead of anything passing to Izzy outright, it's going to go instead to her special needs trust. And that was important for that. And then also my parents, as part of their what they wanted to leave their grandkids, is they created 529 accounts for all the grandkids. Well, I don't know what the future holds for Izzy as far as secondary education, but I have talked to them about, hey, if you want to take her share and roll it into an ABLE account for her benefit now, that ABLE account can also be used to pay for her education. It can be used to pay for all kinds of things, and gives us added flexibility depending on what her future is. So that was kind of a key conversation to have as well, is, hey, you created these, and you don't have to just simply not give her share anymore, but let's find a way to be creative to direct them into the best possible way that's going to help her in the future. And then also, let's make sure your documents are in a good place, not just mine, so that, she's completely protected.
Yeah, absolutely. That's a great point.
Something else to think about, you wouldn't have to leave money that goes to the ABLE account. Money left in an ABLE account is going to be, depending on the state, is going to be subject to the state recovery program. So that's the one thing that you have to be a little cognizant on ABLE accounts, is that these are subject to recovery, depending on the state. And but if you were to leave money to your child with special needs, and it goes to the ABLE account, although it would be subject to recovery, it would not disqualify from any benefits that she's currently receiving. So that's something else to keep in the back of your mind. And then I don't know about the one risk I think that you probably would be running without getting a guardianship, at least a guardianship of the person, is if there was a situation in which medical care would be needed, like especially emergency medical care, not having someone who would be able to authorize the procedure, that's the thing that I would be the most concerned about.
So would getting a medical power of attorney?
That's what I was talking about earlier.
Yes.
If your child doesn't have capacity,
right.
If I don't have capacity and you put a document in front of me, I can sign the document. It'll look good. It looks perfect. Though it's void. You have to have capacity to execute a document. And you have to understand what you're signing.
Okay, so he's 31 at this point in time. He's his own person. Can he sign, do the required signing to set up a medical power of attorney?
Has he ever had a mental status exam?
Mm-hmm.
And what was the result of that examination? Well, you don't have to. That's private. Was one of the conclusions that this person?
Yeah, he has Down syndrome, and he's he is. Oh, I'm sorry. Sorry, distraction. At any rate, yes, he has Down syndrome, and he's in the severe retardation realm.
Yeah. Now I would.
But that was in public school. That wasn't from any other.
Well, you have to remember, in a guardianship hearing, what normally takes place is there's an examination given to them, to the person, and based upon the examination results, a determination is made as to what powers they would have and what powers they would not. What rights they would be able to exercise. I know voting is pretty low-hanging fruit. Most of the time, people will get the ability to vote and maybe spend $50 or have $50, to spend. That's pretty. Those are two pretty common rights that are that a person would retain. But it's a double-edged sword. If somebody were to swindle your son, like, for example, if he walked into like a Sprint store and thought a phone was cool and he wanted a phone, and he signed the contract to obligate himself to pay for this phone that's going to be, probably $1,000 to buy the phone, and then the service is going to be $100 a month or something like that. If you have capacity, you're going to be bound to that contract. And there are people who will, it's kind of sad, but there are people who will actively seek out people who do not have a guardianship, that may not have full capacity, but their constitutional rights haven't been removed from them. This is a person who's at risk, because technically, under the law, this person, if they have capacity under the law, then they're bound to the contracts that they enter. And so, like I said, I would circle back. If it's a situation where you don't think your son would be in a situation where he could sign a contract, or should be signing contracts or negotiating contracts or anything along those lines, I think it's probably not a very, it may not be the safest place to be. Just having a guardianship of the person, to where, and guardianship of the person can be very restrictive, very narrow, not a lot of expense. Once it's up and running, the guardian of the person can literally just fill out a form and send it into the court. Most of the courts, I'm not sure what town you're in, but the judges are usually very, very kind. The staffs are very supportive. It's not a bad experience. Guardianship, guardianship area of the law is very, I found it to be very, very pleasant. And most people are bending over backwards to help. But the thing that I would be concerned about is if your son is not in a position to where a doctor would be able to immediately walk in and see that he can give informed consent, I would be exceedingly concerned that that would be an issue.
Do we have any other questions? Was there any questions in the chat? Any more questions in the chat?
No, just a couple comments that I've been responding to privately, individuals. So
Awesome.
that's about it. There was one participant who said that they had an experience, right, that their son could tell the attorney that he wanted his mom to tell the doctors what to do, that they deemed he had cognitive enough capacity to give a medical power of attorney. That, again, that's just this particular case, right? That doesn't mean that every court, every attorney, every situation is going to be viewed that same way. That's just a firsthand experience from someone that's on this session tonight. So, again, I think to reiterate what we've kind of said the whole time, it just comes down to your personal situation, right?
Yeah.
And make sure that, as David was saying, you evaluate the risks. You look at what are the risks you're comfortable taking, and then what do we need to mitigate against, right? What are those risks that we need to get rid of in order to make sure that, again, your family, your resources, your loved ones are protected to the extent that they need to be. That's kind of where I boil it down.
Yeah. Well, a lot of the one thing that is kind of a legal documents
Oops.
Uh-oh. Do we have our first?
validity, documents validity is going to be, I'm sorry, I keep cutting out. The legal documents validity is going to be determined by a court. And if a doctor is willing to perform the service, I've seen this multiple times. A lot of times what will happen is where the way you know that there's an issue is you can look through a nurse's report, and when you see them, when you see the client's file, and you see the nurses making the notation, so-and-so was in the room with me when I told him about blank, or so-and-so was in the room with me, they're already questioning capacity, and they're basically covering their themselves to make sure that they are saying that there was someone else in the room that heard them say whatever it is, you know, how to take the medication or how to do this or how to do that. From an attorney's perspective, who's used to doing that, when I saw those type of notations in the medical file, I knew for a fact that they knew that capacity was an issue.
That's a good point, David.
And you have to remember you know, Mark was talking about predatory creditors. They're out there. There are people who are actively hunting people who are of diminished capacity. They'll get on the phone and they'll start dialing. Especially older people, when they're starting to have the onset of dementia. You know, they're oftentimes very lonely and they'll talk on the phone. If they have capacity and they basically sign off and sign up for $10,000 siding, which should be made out of gold, guess what? That's exactly what they're looking for. They're looking for people that they can get onto a contract that basically have have capacity, and it's a gotcha.
All right. Okay, if we don't have any other questions, we're going to go ahead and probably go ahead and conclude.
All right. Well, Heather, thanks again for allowing us this opportunity to be here and with your group. You know, everybody, thanks for hanging in there with us, and hopefully we made it entertaining along the way. Not too bland, because some of the stuff, it's just, I mean, it's all the technicalities, right? So we try to keep it entertaining and you know, not a, so the rule says this and this, that, and the other. So anyways, we hope you guys enjoyed it. But thanks for being here.
Thank you so much.
Thank you.
Great, thank you.
All right, Heather, I'll connect with you after the fact on everything. How about that?
Yep, that works.
Awesome.
Just want to, hold on. How do I take okay. In the recording. And then, how do I get my hosting capabilities back?
I don't know. That's a mic question.
Oh.
Heather, I got you. What you do is you actually, in the participants list, you hover over Mark, and then you click More, and then Reclaim Host.
Oh, hold on. Where'd it go? Well, hold on. No,
All right. Good night, y'all.
they won't let me.
See you guys. Let me see.
Mark,
Hang on.
you can give her the host privileges.
That's what I was doing.
Got it.
There you go. I made it easy.
Okay. All right. Then I'm going to go ahead and sign out. And then, yeah, we'll just connect afterwards and touch base on everything. All righty.
Sounds great.
All right, guys. Thanks so much.
All right. Thanks, everybody. Brett, appreciate it.
You're welcome. Bye.